All right, this is part three. To continue, they were given three, or after they served me with a eviction notice. They come by, stop by, serve me with the notice. I turned around and filed. This was a document I filed in the court. Well, in their court, from our court, the consular court. Okay, this is a notice of default judgment because they didn't answer. Misrepresented instrument, bill of attainder, foreign bill of exchange, styled as case number 24CV34104, and titled Summons for Unlawful Detainer, Civil Claim for Eviction, dated November 25th, 2024, and the unconstitutional de facto administrative hearing scheduled for December 30th, 2024, which includes my inherited ancestral estate in reversion known as 2825 Blue Rock Road, apartment 11, Cincinnati, Ohio. The title of this document is a affidavit of fact and notice of default judgment. Now, the default judgment is based on this law. Once a jurisdiction is challenged, the court cannot proceed where it clearly appears that the court lacks jurisdiction. The court has no authority to reach the merits, but rather should dismiss the action. Now, we come down here. Again, like I said, on December 18th, they were served with a writ of quo warranto, which was entered into the record of this de facto case, and you were given 3 days from that date to answer and produce evidence of your alleged jurisdiction and Article 3 judicial authorization, amongst a list of other things for the record. You have failed to answer, and I didn't put it's a typo, didn't put produce, but produce evidence. You failed to answer and evidence within 3 days, which constitutes default and serve as conclusive evidence of your admission by silence or acquiescence to the statement of facts and the redress listed in the affidavit of fact, writ of quo warranto, dated December 18th, 1440, Morse calendar year, 2024, Christian calendar year, and your lack of jurisdiction and fraud. Therefore, this court ordered, wherefore it is hereby ordered and the judge that the default judgment and the same is hereby entered against you, Pavin Pratt, or however you pronounce his name. Some guy that ain't got a nationality here. That's what that looked like to me. But anyway, acting as clerk of courts for Hamilton County Municipal Court, D. Andrew Heyman and Matthew W. Fatter, acting as attorneys for Heyman Law, LLC, and Jeffrey Schwerber, a German, acting as Executive Chief Officer for R&B Blue Rock LLC in care of JAG Properties. Okay, this court ordered that, let's see, some more. Okay, the immediate dismissal with prejudice and closure of the de facto case number 24CV34104 and any other attachments associated therewith for lack of jurisdiction and fraud, as a municipal corporate construct lacks the status, venue, and subject matter jurisdiction to negotiate treaties and diversity of citizenship issues in relation to property and estate matters. Excuse me. The total amount of $5,160,000,000 payable in lawful money of 0.999 fine gold due forfeit. In addition, economic necessity That word "and" shouldn't be there, but economic necessity cannot justify a disregard of constitutional guarantees. That's Anderson Law Review. That's out of the 16 American jurisprudence. That's law. No public policy of a state, that's statutes, codes, ordinances, administrative regulations, municipal ordinances. That's no public policy of a state can be allowed to override the positive guarantees of the U.S. Constitution. This is law. For anybody to act contrary to that, that is an overt act of treason. It is further ordered and adjudged that a judgment lien be placed on the same and is hereby entered against the oath of office, surety bond, property, real and personal, corporal and incorporeal, and assets belonging to or in the name of you, Privin, however you pronounce your name, D. Andrew Heyman, Matthew W. Fader, Jeffrey Schwarzberg, and your spouses, your heirs, successors, assigns, and belonging to or in the name of the city of Cincinnati, because you're responsible for this municipal court as its parent corporate entity. And all these other corporate entities or subsidiaries named to secure the performance and payment of this judgment and to levy such property and assets if payment cannot be made by you no later than 30 days from the date of this judgment, unless settlement can be made before that date. And then the last here is says it is hereby ordered and adjudged that these obligations of contract be carried into execution, which is the law that binds the parties to perform their agreement, and both state and national constitutions or contracts by which agents thereof are bound. So as I have clearly demonstrated, this is a clear overt act of treason. They went ahead and they called themselves, I guess, making a ruling on the 30th according to the thing. So this is what was filed today, right here. Let's see. This is the writ of error. Okay. Now, in this writ of error, the stare decisis law was still. Here we go. Let me pull this up here. Again, once jurisdiction is challenged, the court cannot proceed where it clearly appears that the court lacks jurisdiction. The court has no authority to reach the merits, but rather should dismiss the action. Okay, now, I said for the record, I am Zoser-Ra Netherket El, a Moorish American national, not a U.S. citizen or stateless person, natural person in full life, in propria persona, not pro se, ser juris, authorized representative of ex-il or ex-real, that's a straw man name. That all capital name is a straw man name. The only place you're going to go and find people names, everybody names spelled in all capital letters is the graveyard. They're talking about the dead. Anyway, it says, I am an Aboriginal sovereign national to this land by just sanguineous, and as such, you and your private foreign de facto corporation acting on administrative agency, i.e. Hamilton County Municipal Court, Incorporated, do not have or possess lawful jurisdiction to hear, present, or pass judgment in any manner concerning my affairs under your quasi-civil that should be non-jurisdictional tribunal of a private foreign color of law process. I got a typo there. Non-sanctioned. Non-sanctioned. That should be non-sanctioned tribunal. Yeah. It says, let me start over. Do not have or possess lawful jurisdiction to hear, pass, present, or pass judgment in any manner concerning my affairs under your quasi-civil, non, I forgot the word again, tribunal of a private foreign color of law process. Moreover, on December 18th, you were served either directly or by or through. Well, they were given 3 days. We already been over that. They failed to answer and produce evidence on the writ of quo warranto. Furthermore, therefore, let me start here. It says you have failed to answer and produce evidence within 3 days, which constitutes default and serves as conclusive evidence of your admission by silence and acquiescence to the statement of facts and redress listed in the affidavit of fact writ of quo warranto dated or filed on December 18th, 1440, Morse calendar year 2024, Christian calendar year, and lack of jurisdiction and fraud. Furthermore, your lack of jurisdiction and fraud is proved by conclusive evidence, e.g., affidavit of default, received by you, entered into the record of case number 24CV34104 on December 27, 2024. Therefore, your continued attempt to erroneously schedule another de facto administrative hearing for December 21st, 2025, or any other date thereafter under color of law, by your color of authority, in want of jurisdiction, constitutes fraud and the violation of my right to due process of law, and which is guaranteed to be secured under Article 3, Section 2, and the Fifth Amendment of the Constitution for the United States of North America. Wherefore, it is ordered and adjudged that a writ of error, and the same is hereby entered against you, the clerk of courts, Jacqueline Parcell, acting as administrative clerk / magistrate, and D. Andrew Heyman, Matthew W. Fader, acting as attorneys for Heyman Law, LLC, and Jeffrey Schwarzberg, how do you pronounce that guy? Acting as Chief Executive Officer for RMB Blue Rock LLC and Carajag Properties, for the following judgment to be recovered by I, Dr. Zoser-Ra L, acting as authorized representative for the estate of X-Rail, all caps name, in accordance with Articles 20, 22, Treaty of Peace and Friendship 1863, and Article 6, Section 2, orders the herein below stated obligations to be executed without obstruction or delay. The immediate dismissal with prejudice and closure of de facto case number 24CV34104 and any other attachments associated therewith for lack of jurisdiction and fraud. As a municipal corporate construct lacks the status, venue, and subject matter jurisdiction to negotiate treaties and diversity of citizenship issues in relation to property and estate matters. The immediate release and possession of my inherited ancestral estate in reversion known as 2825 Blue Rock Road at Cincinnati, Ohio 45239 in allodium without interruption or condition per my reversionary interest therein as de jure heir apparent by just sanguineous vested with aboriginal title eel to the land and assert my treaty secured right to inherit under Article 22 of the Treaty of Peace and Friendship of 1836 between the United States of America and the Moroccan Empire. It is ordered and adjudged that the collusive action and de facto administrative proceeding under color of law in case number 24CV34104 in the record of the foreign de facto City of Cincinnati, Hamilton County Municipal Court and Hamilton County Clerk of Courts Incorporated, including the de facto administrative hearing scheduled for January 21st, 2025, and for any other date thereafter, and any attachments associated thereto are unconstitutional, notwithstanding, null and void, ab initio, and unenforceable for lack of jurisdiction and fraud. Now, the total amount of $5,160,000,000 and 0 cents payable in lawful money of 0.9999 fine gold coins due forthwith. It is further ordered and adjudged that a judgment lien be placed against the same and is hereby entered against the oaths of office, surety bonds, property, real and personal, corporal and incorporeal, and assets belonging to all parties listed in this action. We're not going to go through the names. It just say it is ordered. And it is ordered and adjudged that at present, the Moore Science Temple of America has a perfected security interest in said property, connotatively referred to as 2825 Blue Rock Road within the corporate jurisdiction of Cincinnati at County of Hamilton near 45239, that the above, as for said, acts constitute a priority security interest purchase of the property described on the Moore Science Temple of America Certificate of Testilium as the United States or U.S. is bankrupt. See attached pages 1 through 9. It is ordered and adjudged that the obligations of this contract be carried into execution, which is the law that binds the parties to perform their agreement, and that both sides and both state and national constitutions are contracts by which agents thereof are bound. That's a U.S. Supreme Court case. Then we go to stare decisis law, where rights secured by the Constitution and treaties are involved. There can be no rulemaking or legislation which would abrogate them. Let me clear that up. Okay. The state may not convert a secured liberty into a privilege and convert a secured liberty into a privilege and issue a license and fee for it. That's called escheatment. But the case is Arizona State Miranda versus Arizona. So again, these people are acting in fraud. And I don't really need to show all of these, but here is the Moore Science Temples. This is our perfected security interest and lien In this property, as you can see from the last page on here, we hold the deed. This is the deed to the world's largest estate. And this deed covers 2/3 of all the land on planet Earth. That's how big the Moore's estate is. So, let me see. No, not there. Here's that one. Hold on. Let's see. Those are the 9 pages. Well, those are the 9 pages, but this here is the most important one here. This is the document that, again,